Good afternoon, and thank you for joining us for an MP webinar covering New Age of Accommodation Requests and HR Evolution. I'm Katie Kreider, Marketing Manager here at MP, and for those of you joining us on a webinar for a very first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as a proactive, reliable service and a deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenters for today's program, Emily Margrini and Andra Michelin. Emily is an HR partner at MP, and she provides HR support to small, medium, and large-sized businesses in a variety of industries. She has her BA in Human Resource Management and has worked in the HR field since 2016. Emily is also a SHRM certified HR professional. Andra is an HR partner at MP and provides strategic HR consultation to clients. She has over 10 years of experience in HR, and she is a BA in business with a focus in HR from the University of Miami in Florida. She is a SHRM certified HR professional. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out a recording of the webinar later today, along with all of the slides. So before I turn the mic over to Emily, we do have 2 poll questions for you that we would love for our audience to be involved in. The first one is going to be, have you seen an increase in accommodation requests? So you've seen a major increase, minor increase, no increase, and you're just here to prepare. Awesome. Look at all those answers. So we've seen 31% of people have seen an increase in their accommodation requests, and 39% have seen a minor increase, with only 14% seeing a no increase. Awesome. So the next poll that we're going to ask is, are you facing challenges with accommodation requests? So are you here because you're just trying to prepare, or you don't have accommodations, or you've been struggling? Amazing. Over 50% are sometimes facing challenges, and most, 28%, the next highest is 28% of just trying to prepare. So we appreciate your participation in our polls. So with all of that, I'm going to hand the mic off to Emily.
Hi, everyone. Good afternoon. My name is Emily, and as Katie stated, I am an HR partner here at MP. I'm really looking forward to presenting this webinar today with another amazing HR partner at MP, Andra. Today's topic is the ADA, American with Disabilities Act, and responding to accommodation requests. These are the topics we will be discussing today as shown on the screen. ADA basics, so what exactly is the ADA, what employment practices are covered, and what types of individuals are covered, and more. What justifies a reasonable accommodation, and recognizing requests for accommodations as well. How it works when leave laws intersect, and some ADA best practices. And as long as there's time, we will have a question and answer session at the end as well, but feel free to chat them away as well. Let's go ahead and dive right into the ADA basics to set a good foundation for the rest of the presentation. What is the ADA? The American with Disabilities Act protects individuals with disabilities from discrimination in employment, programs and activities covered by state and local governments, accessing goods and services offered in places like stores, hotels, restaurants, doctors' offices, etc. The ADA aims to ensure that people with disabilities have the same rights and opportunities as everyone else. What is the ADA? Title I requires employers to provide reasonable accommodations to qualified individuals with disabilities, unless doing so would impose an undue hardship on the employer. It also prohibits retaliation against individuals who assert their rights under the ADA. The ADA also prohibits an employer from retaliating against an application or employee for asserting his rights under the ADA. The ADA applies to employers with 15 or more employees, state and local governments, employment agencies, and labor unions. It is important to keep in mind, however, that many states have adopted laws that prohibit discrimination against individuals with disabilities that apply to employers with fewer than 15 employees. These state laws mirror the protections provided by the ADA, but apply to smaller employers or provide additional protections beyond those of the ADA. So it's super important for employers to be aware of both federal and state laws regarding disability discrimination to ensure compliance. What employment practices are covered? ADA makes it unlawful to discriminate in all employment practices such as recruitment, hiring, promotions, training, layoff, pay, firing, job assignments, leave, benefits. These are just a few examples of the employment practices covered under the ADA. The law aims to ensure that individuals with disabilities have equal opportunities in the workplace and are not subject to discrimination based on their disability. Who is protected under the ADA? The ADA defines a person with a disability as someone who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as such having such an impairment. The ADA also protects individuals who have a record of a substantially limiting impairment, which refers to individuals who have a history of a physical or mental impairment that substantially limits one or more major life activities, but may not currently have such a limitation. And that's a key piece we want to keep in mind here, current. For example, someone who has cancer that is in remission, or someone who has a previous mental health condition but has recovered. The law also covers people who are regarded as having a substantially limiting impairment. This category includes individuals who may not have an actual impairment that substantially limits a major life activity, but are treated as if they do by others. This could include someone who is perceived to have a disability based on stereotypes or assumptions, even if those perceptions are incorrect. Now, what is a major life activity? Examples include hearing, speaking, walking, working, thinking, seeing, breathing, learning, concentration, communicating, performing manual tasks, interacting with others. These definitions are important in determining whether an individual is protected under the ADA as someone with a disability, as the impairment must, again, substantially limit one or more major life activity to qualify for a protection under this law. Here are some examples of a physical impairment. So this is included, but not limited to blindness, deafness, cancer, cerebral palsy, HIV infection, blindness, diabetes, multiple sclerosis, epilepsy, emphysema, muscular dystrophy, and again, diabetes. There are many other physical impairments as well that may qualify as disabilities under the ADA, but depending on their impact on an individual's ability to perform those major life activities that we discussed in the previous slide. Here are some examples of mental impairments, again, include but are not limited to schizophrenia, learning disabilities, intellectual disabilities, autism, and again, there are many other mental impairments that may qualify as disabilities under the ADA, such as attention deficit hyperactivity, otherwise known as ADHD, and even anxiety disorders, all coming down to their impact on that individual's ability to perform major life activities. Who is a qualified individual under the ADA? The applicant or employee must satisfy job requirements for education, experience, skills, licenses, and any other job-related qualifications, and be able to perform tasks essential to the job with or without reasonable accommodation. The individual must also not pose a direct threat to the health or safety of themselves or others in the workplace. Employers are required to provide reasonable accommodations to qualified individuals with disabilities to enable them to perform the essential functions of the job, unless doing so would impose an undue hardship on the employer. And we will be discussing that in further depth a little bit later in the presentation. We do have a little quiz question we thought would be fun. This one we can kind of just answer on our own. But it is an individual does not have a disability under the law if he or she is A, an active alcoholic currently drinking, B, used unlawful drugs in the past and currently attends a 12-step program. C, used unlawful drugs in the past but is not in treatment now. D, currently uses unlawful drugs or abuses prescription medication. Take a little bit of time, pick an answer. The answer is D. So the current unlawful use of drugs is not regarded as a disability under the ADA. The ADA does not, it does protect individuals who have successfully completed a supervised drug rehabilitation program and are no longer engaging the illegal use of drugs. The ADA does protect individuals also who are currently participating in a supervised drug rehabilitation program and are no longer engaging in the illegal use of drugs. And in these cases, individuals are protected from discrimination based on their past drug addiction, but employers may still require that employees not currently use illegal drugs as a condition of employment. Here's another one. So what should a manager tell an employee who asks why a coworker regularly leaves early when the manager knows the schedule is a reasonable accommodation? A, mind your own business. B, count your blessings. He only has the schedule because he's sick. C, the schedule is an accommodation. And D, none of the above. Take a bit of time to look at this and get your answer together. The answer is D, so none of the above. And we wouldn't want to say any of these things to a coworker who is inquiring. Information regarding an accommodation or disability should be on a need-to-know basis and should remain confidential. Last one, which of the following would be a valid reason to deny accommodating an applicant or employee with a disability? A, the individual cannot perform the essential duties with or without an accommodation. B, the individual's disability results from current abuse of prescription medications. C, the only helpful accommodation is to provide the individual with a hearing aid. And D, all the above. Take some time, get your answer. Answer is, again, D. I just realized these are all kind of a pattern of being D. But the answer is all of the above. It's important to note that employers are not required to provide personal devices, for example, hearing aids or eyeglasses. There is a difference between a personal device versus a workplace device. Let's go into a little bit more about what an essential job function is. So essential job functions are the basic job duties that an employee must be able to perform with or without reasonable accommodation. These functions are typically outlined in a job description and are a crucial aspect to the core purpose of a job. Typically, essential functions of a job often involve tasks that are specialized or require specific skills or qualifications. How are essential functions determined? Is the task necessary to perform the job? These are some of the questions that you're going to want to ask. How frequently is the task performed, or how much time is spent performing the task? Can the task be redesigned or performed in another manner? Can the task be reassigned to another employee? In addition to a written job description, the EEOC will consider as evidence an actual work experience of past or present employees in the job, time spent performing a job function, and consequences of not requiring that an employee perform a function. Now, what is a reasonable accommodation? Let's discuss that a little bit more. A reasonable accommodation is a modification or adjustment to a job, the work environment, or the way things usually are done that provides a qualified individual with a disability and equal employment opportunity. Some examples of a reasonable accommodation may be perhaps modifying work schedules or providing flexible hours, maybe providing additional training or support, or even modifying job duties or reassigning to another vacant position in the company. Those are all viable options. The ADA requires reasonable accommodation in 3 aspects of employment. 1, to ensure equal opportunity in the application process. 2, to enable a qualified individual with a disability to perform the essential functions of the job. 3, to enable an employee with a disability to enjoy equal benefits and privileges of employment. The overall goal is to ensure that individuals with disabilities have equal opportunities in the workplace again and can still perform their job duties effectively unless providing an accommodation is in fact not reasonable and would cause that undue hardship on the employer. So I know we mentioned undue hardship a couple of times. What exactly does that mean? So an undue hardship means that an accommodation would be unduly costly, extensive, substantial, or disruptive, or would fundamentally alter the nature or operation of the business. There are factors to consider when determining an undue hardship. Those would be cost of the accommodation, employer size, financial resources, and the nature and structure of its operation. It's important to note that each situation should be evaluated individually, taking into account the specific circumstances of the employer and the nature of the accommodation that was requested. Employers should engage in an interactive process with the individual requesting accommodation to explore all possible options before determining that an undue hardship exists. In the interactive process, a discussion about an applicant's or employee's disability, the applicant or employee, healthcare provider, and employer each should share information about the nature of the disability and the limitations that may affect his or her ability to perform the essential job duties. This discussion is the foundation of compliance with the ADA. The employer should review the accommodation request from the employee or his or her healthcare provider. While the ADA does not require the request to be put in writing, having documentation or a paper trail of the request is just best practice. Employers should also obtain written medical release or permission from the employee. The employee's healthcare provider may not disclose information or answer questions about the employee's disability without the employee's permission. An employer should also ask the employee to provide appropriate documentation from the employee's healthcare provider or rehabilitation professional regarding the nature of the impairment, its severity, the duration, the activities that may limit them by the impairments, and the extent to which the impairments limit the employee's ability to perform, again, those job essential duties and functions. It's also important to document each step in the interactive process, like we discussed. The employer should keep a record of all discussions that are held, the accommodation options considered, and then what the final accommodation provided was. Now let's dive into the reasonable accommodations for applicants specifically. Accommodations for applicants. Employers have an obligation to make reasonable accommodations to enable applicants with disabilities to apply for jobs. These accommodations are designed to ensure that the application process is accessible to all candidates. Some examples of accommodations for applicants could be accessible interview location for people with mobility impairments, sign language interpreter for a person who is deaf, reader for a person who is blind, modified testing for a person with a learning disability, or even providing accessible application forms that may be in alternative formats, such as large print or electronic formats that are compatible with screen readers. We do recommend as a little tip to include information about the essential functions of a position in job advertisements. This does provide transparency and accurate expectations for what the job will actually entail, and it also ensures efficient recruitment by attracting candidates who will be well suited for the role. We also recommend including a statement in job advertisements that do not discriminate on the basis of disability or other legally prohibited basis. The EEOC provides the following example. We are an equal opportunity employer. We do not discriminate on the basis of race, religion, color, sex, age, nationality, origin, or disability. Providing a statement such as this serves several important purposes, such as demonstrating compliance with anti-discrimination laws, promoting diversity and inclusion, improving employee morale, and more. Now let's discuss in further depth what may be justified, again, as that reasonable accommodation for employees. First, I wanted to provide you all with this link if you all would like to just jot this down, or like Katie said previously, we will be providing you all with a copy of these presentation slides afterwards. But Jan is an excellent resource for information about disability etiquette that you can check out at any time. If you have a specific scenario, I think there's an FAQ on there that can talk you through that. It's just a really, really great resource to refer to. Reasonable accommodations. There are a number of possible reasonable accommodations that an employer may have to provide in connection with modifications to the work environment or adjustments in how and when a job is performed. Some of those reasonable accommodations could be, we talked about a few of these earlier, but making existing facilities accessible, maybe restructuring the job, part-time or modified work schedules, acquiring or modifying equipment, changing tests, training materials, or policies, providing qualified readers or interpreters if needed, and reassignment to a vacant position. Reasonable accommodations does not include removing those essential job functions, creating new jobs, and providing personal need items such as eyeglasses and mobility aids. An employer is not obligated to provide an employee's preferred accommodation if another reasonable accommodation exists that enables the employee to perform essential job functions. The specific accommodation provided may vary based on the circumstances and the nature of the disability. It can be on a case-by-case basis. It's going to be really dependent on the situation. The key is to ensure that the accommodation provided is effective in enabling the employee to perform their job duties. And this is where that interactive process would come into play. The interactive process does not just end because an employee's initial accommodation request is unreasonable. If this occurs, the employer must explore alternative accommodation options. For example, an employee with a mobility disability requests a modified work schedule to accommodate medical appointments related to their disability. However, the employer determines that the requested modified work schedule would cause an undue hardship to the company due to operational needs. The employer could explore alternative accommodation options, such as allowing the employee to telecommute for a portion of their work week, having kind of a hybrid work schedule to reduce the need for travel to the workplace, or adjusting the employee's start or end times to accommodate medical appointments while still maintaining the required hours of work and making sure that the work gets completed, or by providing additional breaks or flexible work times or break times to allow the employee to attend those medical appointments. By considering alternative accommodation options, the employer can still provide an effective accommodation that meets the employee's needs while also addressing operational requirements. And now I'll be turning it over to my colleague, Andra. Thank you all.
Thanks, Emily. Hi, everyone. As Katie stated, I'm Andra Meiklin. I'm an HR partner at MP. I'm going to keep this going and we'll talk about recognizing requests for reasonable accommodations. All right, so employers are obligated to provide reasonable accommodations only to applicants and employees with known disabilities. So if it is not known to you, you can't be making up for that unless a disability and the need for an accommodation are completely obvious to a reasonable employer. It's the individual's responsibility to inform the employer of an accommodation that's needed. So what does that really mean? So according to the EEOC, an individual may use plain English and doesn't need to mention the ADA or the use of the phrase a reasonable accommodation when requesting an accommodation. So they, if they might come up to you and say, under the ADA, I require this accommodation, but oftentimes it will look a little bit different at the way that they state it. I'm like, go to the next slide, please. Thanks. Next. Just a little bit of HR humor. Right, is this a request for an accommodation? Not really. This would not work. But oftentimes I feel like for employers, it feels like this way, that employees are coming to them with this. Next slide. So oftentimes, again, I said that it doesn't come out as easily as saying, I need an accommodation under the ADA. It might come out a lot of times, knowledge of a disability arises during the discussion of performance problems. So the employee gets a poor performance review oftentimes, or a warning because of poor performance. And then the employee explains that there's a disability and that's the reason. So this triggers the employer's obligation to investigate and define possible reasonable accommodation. So I'm going to say that again. This triggers the employer's obligation to investigate and define possible reasonable accommodations. And this is so important because I think a lot of times for employers, you know, it's easy to, or for supervisors, they oftentimes will think that this employee is kind of just giving an excuse and they don't really need an accommodation, but they've been told that they have poor performance. So they are looking to, you know, say that there's some other issue at hand. But if an employee brings this up to a supervisor, it's your obligation to investigate it. Next slide, thanks. So with that said, if this happens during some sort of performance evaluation or a review or a warning notice, a performance improvement plan, you can continue to move forward with the employment action decision that was made based on the facts known at the time, and then address the need for the accommodation. So you can keep those two things separate. So as I said, again, accommodation requests come out in different ways. So I'm just going to walk through a few different ways that and are these accommodation requests. So Alicia tells her supervisor, I'm having trouble getting to work at my scheduled starting time because of medical treatments I'm undergoing. So is this an accommodation request? It is. This is an accommodation request. Even though there's no question mark, there's no, can I have an accommodation? Based on what they're saying, the accommodation might be starting at a different time. You could go through the interactive process with this employee. So Ben tells his supervisor, I need 6 weeks off to get treatment for a back problem. So is this an accommodation request? So yes, maybe. It might need a conversation because it could require FMLA and an accommodation. So this would also require the interactive process after he states this. Charlene, who uses a wheelchair, began a new job today. Charlene informs the employer that her wheelchair cannot fit under the desk in her office. Is this an accommodation request? Yes, this is an accommodation request. So, and this is one of the ones that I think a lot of times people think of as an accommodation request, because wheelchair, we understand that that's a disability and we can see that. It doesn't fit under the desk. And so there's something that can be, there's an accommodation that can be made. So this is an accommodation request, but if Charlene, I think Emily touched on this before, that if Charlene is asking for a wheelchair, that is not necessary, but something like a desk that is part of your office, you are required to make an accommodation if there's not an undue hardship. And it would assist with her doing her job. So this one, Derek tells the supervisor that he would like a new chair because his present one is uncomfortable. So my initial reaction to this is that no, this is not an accommodation request, but because basically this statement's insufficient to put the employer on notice. He's not linking the fact that he needs a new chair with any medical condition. However, again, you know, still might require just kind of some inquisitive questions and asking him a couple more questions, because maybe he does actually have a required accommodation and have a disability, but he's not stating that directly. Jenny's supervisor met with her today to evaluate her performance this year. She received a fair rating because her work is slower than her peers. Jenny explains to her supervisor that she is working slowly because her multiple sclerosis, that word is very hard for me to say, but you can read it on the screen, has progressed. So this is an accommodation request. This is something that you can go through the interactive process. So I know I went through a lot of different scenarios and questions about if these are accommodation requests. My hope is that what you take away from this is that a lot of these required an interactive process and some follow-up to figure out if it is required and what the accommodation would be. And another takeaway that I hope that you got from this was recognizing the role of supervisors. So, you know, again, employees might not be walking into HR's office and saying, I need an accommodation. They are often the supervisor is the front line for employees. And so they are dealing with these. And so if you are at this training and you are a supervisor, that's great. If you are an owner of a business or you're in HR, and one thing to train your managers on is to make sure that they can recognize an informal request for an accommodation. And aware of their, they need to be aware of their limited role in responding to requests and who to contact for assistance. They need to be provided with coaching as the process proceeds as well. So it's not up to the supervisor to say, oh, they were just complaining because they had a poor performance review. They don't really need an accommodation. That's not their determination to make. But what they are in charge of is making sure that it gets brought to your attention or HR's attention. So we'll talk now about when leave laws intersect. So this is often referred to as the Bermuda Triangle of employment law. So the interplay of the Americans with Disabilities Act, ADA, which we've been talking about, the Family and Medical Leave Act, FMLA, and workers' compensation can be complicated to navigate, and sometimes they overlap, intersect. So the FMLA is a federal law designed to help workers balance job and family responsibilities by giving employees up to 12 weeks of unpaid leave for specific reasons, including a serious health condition or to care for an immediate family member who has a serious health condition. And this applies to employers with 50 or more employees within a 75-mile radius. And then taking a step back and going over what workers' compensation is, it's a form of insurance that provides financial assistance, medical care, and other benefits for employees who are injured or disabled on the job. And as a general rule, workers' compensation laws apply to all employers with one or more employees. However, you would need to look at your state-specific laws and what the coverage, how the coverage varies by state. So now we've talked about those ones as well. When they interact, when employees need time off because of a medical or disability related issue, it's important to remember that they may have rights under all of these laws at the same time. In certain circumstances, provisions of the ADA, the FMLA, and workers' compensation laws can apply to the same employee. So when you are dealing with something like this, the first step for you to take is which laws apply to your organization, then determine which laws cover that particular employee situation. So you determine the laws that apply to your organization based on your size, for example. Then you could look at, what the situation is with that employee. Is the injury work related? Therefore, it relates to workers' compensation. Does the employee have a serious health condition? Does the employee's condition meet the definition of a disability? And on top of this, it's important to remember that there are also state leave laws that might apply, like state disability leave or paid sick time laws. For the purposes of this training, we're not going to delve into state-specific leaves, but they may apply to your organization as well. So you determine the employee's benefits and or the entitlements under the relevant laws. That would be the next step. Evaluate whether the employee is entitled to reinstatement once they're able to return to work, and evaluate whether the return to work poses a direct threat to the health or safety of the employee or others in the workplace. Let's go over an example of this. So for an employee absence, Alice is an assembly line worker, has called in sick for 3 days, citing extreme back pain. She has been with ABC Manufacturing, a company with over 500 employees, for 3 years, working full-time with very few absences. Alice calls in sick for the 4th day, stating that she was examined by her doctor, who took x-rays and stated that she needs complete bed rest and possibly back surgery and will be unable to work for an extended period of time. Alice states that her doctor thinks the condition is caused by the type of work she has been doing. All right, so let's break this down. ABC manufacturing is covered by which employment laws? Because it states that it's over 500 employees, they are covered by FMLA, because the threshold for that was 50 employees. They are covered by ADA because they have more than 15 employees. And also workers' compensation, because our general rule of thumb is if they have 1 or more employees, they are covered by workers' compensation. So all 3 of those could be in play. And then what leaves of absence is Alice eligible for? And so it's actually possibly all 3, depending on the severity. Is the injury work-related? Yes. It sounds like it could be, based on what her doctor's saying. Does the employee have a serious health condition? Possibly. Does the employee's condition meet the definition of a disability? So it depends on what the outcome and what her doctor states. And then what other employment laws might come into play? State sick, family, medical leave, and/or disability could also come into play on this. And ABC manufacturing is covered under and must comply with the ADA, FMLA, and the state workers' compensation laws. And Alice might be eligible for protection under the ADA and FMLA, depending on the severity of her condition. A workers' compensation claim must be filed and a determination must be made as to coverage. And so we've been talking about leave versus and talking about insurance as well. So keep in mind that leave laws provide job protected leave, while short-term disability or workers' compensation will supplement the income. So they're a little bit different in that sense. So just be aware of that. The next thing to keep in mind is leaves as a reasonable accommodation. So according to the EEOC, leave qualifies as a reasonable accommodation when it enables an employee to return to work following the period of leave. So the ADA mandates that employers consider providing unpaid leave to an employee with a disability if the employee requires it. So what exactly does it mean? So this sometimes is a question for employers that, what does that look like? So that this is why it's important to have a return date. Numerous federal appellate courts have held that an employee is not entitled to leave as a reasonable accommodation if the duration is unknown. So some courts have indicated that individuals seeking excessively long or undetermined leaves don't need to be accommodated because they technically are not otherwise qualified for their jobs under the ADA. Remember that the ADA protects individuals with disabilities who are otherwise qualified with or without the accommodation to perform the essential functions of their job. We'll talk a little bit about some ADA best practices. Wrap this up. So 5 common ADA mistakes. Not realizing that a request for an accommodation has been made. So that's why I know we had a lot of slides about, is this an accommodation request? But it's such a big part of this is recognizing that somebody has made a request. Permitting frontline supervisors and managers to evaluate accommodation requests. They need to be coached on what to look out for with an informal request and who they should go to and how they should proceed. Delaying a response to an accommodation request. So you need to respond expeditiously and take all requests seriously when it comes to an accommodation once you've been basically put on notice. Discontinuing the interactive process because a reasonable accommodation is not obvious. So as we said before, that there could be, maybe you're going through the interactive process, but there's a reason it's called a process, right? It's there might be some iterations of it. The first accommodation that the employee comes up with might not work for your business, or the accommodation that you come up with might not work for the employee. So you might need to be creative and work together to figure out what the accommodation could be that's reasonable. And then inadequately documenting the entire accommodation process. So documentation is extremely important with the accommodation process. So making sure that you are documenting it. So let's talk about pre-employment process in the ADA. So Emily talked about this a little bit, but to go into some best practices with this, employers may not ask disability questions during the pre-employment process, whether on a job application, in a job interview, or in the background and reference checks. So just to talk about some things that you are allowed to say, questions an employer may ask. Next slide. Can you perform any or all of these specific job functions? Please describe or demonstrate how you would perform a specific task. Please note, though, that that is something that you need to be asking of all applicants, unless there's an obvious disability related to a job function, and the employer may need to provide reasonable accommodation for the demonstration. Another question that you are allowed to ask is, can you meet the attendance requirements? What was your attendance record at your prior place of employment? And this is pretty timely because I just read about a week ago, there was Hospital Housekeeping Systems. It's a company based in Texas. They were required to pay $520,000 in a disability discrimination suit. The company required employees to take an essential functions test at hire annually and upon return from a medical leave of absence, even when the portions of the tests were not job related. So, and if employees failed any portion of the test, they were fired despite the employees successfully performing the essential functions of their job. So this is an example of they, are allowed to do an essential functions test, and however, it needs to be job related. And the company also did not offer any reasonable accommodations during the test. So that is why they were held liable for this. And let's see. The questions that you are allowed, that you are not allowed to ask. Do you have a handicap or a disability? Do you have any job-related disability limitations that would prevent you from doing the job? So again, for this, you would just go back to one of those questions that you are allowed to ask. Can you perform any or all of these specific job functions? That's something you are allowed to ask. Have you ever received workers' compensation? You're not allowed to ask that. Have you ever been hospitalized, treated for medical or mental conditions? Have you ever been addicted to illegal drugs or treated for drug abuse or alcoholism? Have you ever been absent from work due to illness? So please avoid these questions. And so these are some reminders. It's also why it's so important that your job descriptions are clear on what the essential functions of the job are. Another court case recently, Cloud Beds in November of 2023, a San Diego-based technology platform for hotels, ended up paying a $150,000 settlement for a disability discrimination lawsuit. So they allegedly failed to provide an accommodation to a deaf applicant seeking a remote job in IT administration when he asked for an accommodation in the interview process. So they saw his application, wanted to move him to the next round of the interview process, and he reached out for an accommodation. And they ended his candidacy at that point on the basis that verbal communication and hearing were requirements for the job in the remote setting. And what they should have done was engage in a good faith interactive process, because he was otherwise qualified and they could have gained some insight into what they could have provided as a reasonable accommodation. What's interesting about this is he had 17 years of experience and was able to use different technologies to perform similar IT work. And they had 3 positions open, and they ended up hiring 3 non-deaf candidates with less relevant job experience. So perfect examples of some things that they didn't do were they made some assumptions about the disability and whether this person would be able to do their job. And they also, this one thing that came out of this too is that the ADA protections apply to remote workplaces. So keep that in mind as well. So you can establish policies and procedures. I mentioned documenting these things. So a formal policy and procedure helps managers and HR handle the requests for accommodations properly and consistently. Employees know what to expect if they request an accommodation, and employers document their efforts to comply with the ADA, which is so important. And so you can do things like have a policy in your handbook. That's one of the options. And so to make sure that you have a defined policy for dealing with these things. And so some sample accommodation policies and procedures are also available at JAN, which Emily mentioned before, and the EEOC.gov website has instructions for accommodation procedures as well. That said, I'll pass it back to Katie to close this out.
Awesome. Thank you guys, and we really appreciate your expertise. So to learn more about MP's full service solutions for 2024 and more, and maybe to speak with an HR professional about some of your questions, you can visit our website at mp-hr.com to learn more. Be sure to join us for our upcoming webinar. And March is Women's Month, so we're going to be running a panel of empowering women in the workplace, changing the face of leadership. Visit our website to register and to see the full calendar of upcoming events and available resources. Again, we will be sending out a recording of today's webinar along with the presentation slides this afternoon. Thank you all again for joining us, and have a terrific day.